three Electoral Court judges. They said that there is no evidence before us that the president's address influenced a single voter.
The question here should not be asked whether there's evidence that it influenced a voter, but rather that the question that must be asked must be, what was the subjective objective of the president when he did that speech?
According to their findings of the court, if one has regard to the speech as a whole, it has to be accepted that the objective effect of the presidential address was then to appraise the nation.
What would have happened if the leader of the opposition at that stage, who was John Steenhuisen, also wanted to address the nation and say, in my capacity as leader of the opposition, I want to urge everybody to go and vote, and then use that to show what the DA has done? There would have been an outcry, and I can promise you now that the SABC would not have even aired that. Now, according to us, that is electioneering. The judges in this current matter did not agree with us.
Of course, the DA leader would not have been addressing the nation, but rather his party members.
We will now take all the legal options available to us, which is an appeal, because we...
Yeah, guys, so it actually appears official that the DA might be going for President Ramaphosa once more, in this whole debacle around President Ramaphosa's use of rhetoric and, a claim that was actually an attempt at electioneering.
Good afternoon to you, Mr. Ocamp. So let's just start by establishing your reaction then to the Electoral Court's decision. The court's essentially rejecting your allegations as the DA that President Ramaphosa's address violated the Electoral Act and the Electoral Code of Conduct, and has in fact dismissed assertions that the speech was disguised electioneering. Just your reaction, please.
Good afternoon, Unati. It's always nice to speak to you. Unati, yes, we are disappointed in the ruling that came out today, but we do have the right of appeal, and we will do so. We have discussed this with our legal representatives, and we believe that the court erred in their judgment. We are of the opinion that having a speech like that the president had 3 days before the election is definitely electioneering. It was campaigning by him. If you compare that speech to the speech that he gave at the ANC rally just days prior to that, it is in essence the exact same speech. And to then try to color that in as if it is an address to the nation and urging people to go and vote, it is not the case. If the president wanted to urge people to go out to vote, he could have just said that. But he went on and he really used this, according to our opinion, as an electioneering campaign speech. And we will therefore look into and definitely appeal this matter.
And I do appreciate, of course, your right to appeal. But when you look at what transpired this morning, essentially three Electoral Court judges Dumisani Zondi, Lester Adams, and Sina Yakub, in fact, they said that there is no evidence before us that the president's address influenced a single voter. Perhaps then just give us a sense in as far as what informed your decision in the first place to go this legal route, especially given the lack of evidence as these three judges are purporting.
Unati, I think it's very important that we realize that the question here should not be asked whether there's evidence that it influenced a voter, but rather that the question that must be asked must be, what was the subjective objective of the president when he did that speech? His aim was, according to us, to persuade people to give the ANC another chance. He went on during that address and he bragged about the achievements of the government, of his government, which we know at that stage was an ANC government. So the question is not whether one single voter or 100,000 voters have been persuaded by that address. We must go and look at his intent with that address, and that is where we say his intent was wrong. He was using a state resource like the SABC with a speech that is exactly or in many ways very similar to a campaign speech at an ANC rally that he used just days prior to the speech. So if it was a speech to persuade people to go out and vote, it could have been a very different speech and the content thereof could be very different. But that was not the option that he went for, and that is why we are going to appeal this. So let's see what happens in the appeal matter.
Yeah, and I mean, I don't want to beleague the point, but just on that point that you are raising now, in fact, the court did, look into those merits, and according to their findings of the court, I mean, just to paraphrase what they said, if one has regard to the speech as a whole, it has to be accepted that the objective effect of the presidential address was then to appraise the nation on the readiness of the country to hold national and provincial elections and the importance of having a government, instead of then talking about, just how well the sixth administration performed.
Well, that is what we are saying is, and I'm repeating myself as well now, but if he wanted to give feedback to the country on the importance of having elections and elections having to be free and fair, that should have been the topic of his speech, and it should have been the main topic of his speech, but that was not. He clearly tried to tell the people of South Africa what great government they've got in the ANC at that stage, and that they built on a road for 30 years and that this government must have another chance to carry on with that. Now, according to us, that is electioneering. The judges in this current matter did not agree with us, and therefore we are a party for the rule of law. We will now take all the legal options available to us, which is an appeal, because we do not agree with them. We think that they've erred in their opinion of what happened, and we will now have to ask a higher court to look into this matter and see whether they do agree with us or not. There have been several matters in the past by various parties that you got set down by the Court of Initiation, but then you take it on to appeal, and in several matters we were successful on appeal where we were not successful in the initial matter. So we hope and believe that that will be the case here as well, and that we now got to test this in front of an appeal court.
Just very quickly, as we wrap our conversation, I mean, you were obviously not the only party that felt this way. I know that, of course, the EFF also wanted this matter to be investigated. But what do you then say to those that say, perhaps as you reflect on this particular court outcome, you also just maybe consider that your decision to go the legal route was perhaps not well thought through, that perhaps it was as a result of just how crucial the May 2024 elections were at the time, and that now going forward you should be focusing on other matters?
Nati, there's two very important aspects here. The first one is that we approached the presidency before we went to court in order to see whether we can settle this matter out of court. Us being in a GNU now and having to work together, we approached the president with three aspects that we wanted him to agree to, and then we can carry on. The president at that stage did not want to agree to that, and he said that we must just withdraw our case. Now, the second very important thing is that we've got a responsibility to uphold the law, especially the Constitution of South Africa. Now that the DA is in government, I believe that that obligation carries even more weight. We've got to show that we will not shy away, even though we are in government, we will not shy away from protecting the Constitution and protecting the rule of law in this country. So if we disagree, like we do in this instance with the president and with what he has done, we opted to give him an option out, to admit that some people could have interpreted that speech that he gave as an electioneering speech, and that would have been the end of it. Not to give him a slap on the wrist, but to prevent this from happening in the future again. We cannot have it that state resources are used by one party, but other parties does not have that effect. What would have happened if the leader of the opposition at that stage, who was John Steenhuisen, also wanted to address the nation and say, in my capacity as leader of the opposition, I want to urge everybody to go and vote, and then use that to show what the DA has done. There would have been an outcry, and I can promise you now that the SABC would not have even aired that. So
Mr.
the playing
Okampo, we
field must
have,
be level,
I think your
and we've got
point,
to work on that.
I think your point has been made. Thank you so much for that. But of course, the DA leader would not have been addressing the nation, but rather his party members. But thank you so much again for your time.
Anyway,
Really
this case, which the DA actually speaks about, like we heard from Willie Ocamp now, it actually goes back to the a court case in May. And I found a really interesting report from May that actually speaks to this whole fact. So it speaks about how, that the DA leader at the time, Justin Houston, actually said that President Ramaphosa actually abused his office by using an address to the nation as a thinly veiled disguise for a campaign message. And the DA now want him to pay a fine of 200,000 rand, which now we see that the Electoral Court actually seem to have been dismissed. But the DA wants to take the case back to a higher court and make sure that President Ramaphosa probably meets the obligations for this sentence. So it says that the Democratic Alliance has filed an application. This is as at May 2024. It says the DA filed an application in the Electoral Court challenging President Ramaphosa's, national address, where he actually used the rhetoric as a campaign, what might have been an SO, State of the Nation, as a campaign rally. John Houston said that Ramaphosa abused his office by using this address to the nation, as a disguise for a campaign message. And Ramaphosa's manipulation, and this is now John Houston speaking, he says that Ramaphosa's manipulation was cynical, calculated, and designed to influence the outcome of the election by providing the ANC with unearned airtime that was not made available to any other party contesting the election. Now, it says that the DA is further asking the court to reduce the ANC's vote. This was as at May, to reduce the ANC's vote by 1 percentage point in line with the provisions of the Electoral Act. So in other words, even if this was a request done by May, if the ANC is at 40%, so to speak, if they reduce that percentage by 1.39, so we see that the DA has a long-term approach to really decapacitate the ANC's long-term view to really still maintain the majority of the votes in South Africa. And so this was a case that was shut down by the Electoral Court, as we saw Willie Ocamp really angry in this speech with this journalist. And hopefully the DA actually think that they really want to take this case back to the court to challenge President Ramaphosa and really meet the demand that the DA wants to really reduce their electoral. It says that it wants the court to reduce the ANC's votes by 1 percentage point. All right. And so finally, Justin Houston speaking, he said that not for the first time, Ramaphosa has chosen his correct political party over South Africa. As the president, he should have known better, and he must now be held to account, and that this kind of abuse cannot be allowed by anyone. So I don't know, what do you guys think? I think it's a really strange story anyway, because I think they're all supposed to be working together now in the government of national unity. So if we have the DA taking the president of the government of national unity to court, it's really difficult to understand how things go within there. But anyway, share your thoughts. What do you guys think about this speech by Willie Ocamp, this interview? Share your thoughts in the comments.